Yeah, so hi guys, in this session, what are we going to do for your foundation December 23 exams? We're going to discuss close to 70 to 80 questions from where. First, let me give the agenda for the whole recording video and all the questions. If you're watching this video, class, ensure you are a little prepared with foundation law and then watch. What are all we are going to discuss over here, guys? One, we are going to discuss December 23, your December 23 RTP questions will be discussed. Your December 23 RTP questions we will discuss. Full Sale of Goods Act, Contract Act, Partnership LLP. Then leave December 23 from June 23 till 2021. The last 5 years, more than 5 attempts, the last 5 plus attempts, all the difficult, not all questions, all the difficult RTP questions from June 21 RTP, May 22 RTP, all the difficult past exam questions of last 5 attempts, and all of that will be discussed. So if you can see here, we have here last 5 attempts starting from May 2021 till June 23 RTP. We will try to discuss all the questions till May 23 we will discuss all the past exam RTP questions and past exam questions. Not everything. This put together we have about 58 questions I have picked from this. Only the difficult questions. 58 plus current RTP is another 15 questions. And apart from this, the third one, I am going to discuss own questions, which I have framed. These are own questions. This one, own questions. We have about 20 questions from our entire syllabus, random 20 questions. This is to tell you that, okay, these own questions, if something new comes in the exam, are you able to get the answer? Now, we are going to discuss all these questions and answers. Also tell you how to write the answer for few questions along with the answer key that we have. I'll brief how do we write the answer, what is important in provision, what you can add, what you can reduce in analysis. Some of them ask, should I write facts, should I not write facts? I'll give you 1 or 2 styles options for you to choose. Clear, guys? This session will go on, we start now, will go on for the next 2 hours 30 minutes. We're going to discuss only question answers of all of this. This is to boost your confidence. Now, coming to difficulty, RTP we're going to see fully. Own questions are generally made, some easy, some medium, some difficult. But these main 58 questions are difficult questions. So don't think exam will be like all these questions. We are trying to cover the most complex or difficult questions. There will be easy direct questions like what are rules of offer, how offer will be revoked, type of offer, what are the rights of seller against buyer in unpaid seller chapter, what is characteristics of LLP. You get 20 to 30 marks of direct questions. There you have to memorize and learn. This is for case study application questions. So end of the session, don't expect yourself to know answer for all the 70, 80 plus questions we are going to solve. And I will also be sharing the key solutions for all the questions we are going to discuss. So the own question solution, no, December 23 RTP anyway solution is there, and these questions I will anyway be giving you the solutions. Are you following, guys? I will send PDFs, I will send a drive link, put it in the description of this video if somebody is watching a recording. You guys, I will put it in our group where I will send the drive link for all these PDFs along with the answers, so that later you can read the answer and go through. Because for 80 questions, we are going to do it in 2 hours, so we are going to be fast. So quickly read the question, quick few seconds for interpretation, answer. Some questions you may not get the answer. If it's difficult for everybody, we will discuss. Otherwise, you have the answer to check. Are you following, guys? Agenda is to see how fast you are able to think. And that's why I've told you to read and come. Have you all read, guys? Hello? How many of you read, studied? How many of you know, sir, last 3 days I didn't touch law itself, Prasad? No. Saw movie, Leo movie and came, that's all. Okay. Fine. So that's about it. And since it's going to be a recording, you can also use this later for revision. If you are not confident today, you can read, come back. Still, we have our law exam in few days. So you can again read next few days before you write the law exam, which is in 4 days from now. Okay. So those who have not read so far, use this for revision, again write exam. And those who are watching recording at future point of time, leave the exam, focus on the questions. I mean, I'm not talking about model exam here. Okay. Fine. Let's get into the questions, guys. I will go in random order. No RTP, this, that. I will go. So we have 3 sets. Basically, I'm going to give you 3 PDFs. What are the 3 sets, guys? One is December 23 RTP. You can download by yourself. One is the past 5 attempts and RTPs which I have collated. That will be here. And own questions. And towards the end of the session, I will also discuss for 20-30 minutes 55 plus case laws that we have in our syllabus. I will show you the case law material also. If I just go to the case law material, all the case laws in the study material is given like this for us. The basis will basically be case law number in our book, case law name, facts of the case, what is there in the book or I have taken from the real case. This column is what I wrote. What is the core concept that you should remember from this case? Even if you don't read this part, it's okay. Read this. What is this case law discussing about? One line concept. Exactly which concept? Which act? Which unit in our study mat? Which page number? Page number might change 1 or 2 pages based on which edition of book you are using. This is as per Jan 21 edition. Might change 1-2 pages. And I gave ABC analysis, ABC. A means very important, C means not important. Are you following, guys? Like this for all the case laws in the book, this also we will go through. Are you following, guys? Clear? So we are going to be fast. Let's go back to questions. Okay. We already did a few questions, so let's do the ones we haven't done. So we will come back to this document a little later. Let's, yeah. Okay. I don't want to complicate that difficult question start. Let's start one with RTP question. 2-3 questions here. Jump. I'll keep switching based on the flow. Is that fine, guys? Okay. RTP question 1. It's right there on the board. Sheetal, I will read the question quickly. Sometimes I will let you read. Some I am going to read. Some I will let you read. So we do both. Okay. Sheetal is a dancer. Okay, fine. Entered into an agreement with some school for 50 dance performances. Fine. As per the contract, she was supposed to perform every weekend and she will be paid 8,000 per performance. However, after a month, she was absent without informing due to her personal reasons. Now, is it a breach of contract? Yes. Whether the management has the right to terminate the contract? Yes. She has breached the contract, so we can terminate. If the management of Sharad informs Sheetal about its continuance, can the management still cancel the contract on the ground of subsequently? What they are saying here, they told Sheetal, no problem, you continue. You put leave, no problem, you continue. Later, can they again come and ask her to leave? No, she can't leave. Can the school claim damages it has suffered because of the breach? Yes, if there's any damage, they can claim. Same way, can Sheetal claim money from school for the performance she has done? Quantum merit. She can, if that question is not asked, but she can claim for the work that she has done. Are you following, guys? That's it. Okay. Next. Fine. Next, we'll go and check the answer. Second question. Okay. Paridhi, a minor falsely representing her age, enters into agreement with an authorized laptop dealer, Mittal, owner of laptops, for purchase of laptops on credit amounting to 60,000. She promised to pay back the outstanding amount along with interest by 31st July. She told him in case she won't be able to pay the outstanding amount, her father Ram will pay the money on her behalf. So she is trying to bind the guardian or parents. Can she do that? She cannot do it until the promise given by the father. Father should give the consent. After 1 year, when Pardi was asked to pay the outstanding amount with the interest, she refused to pay the amount and told the owner she is a minor. She can't recover a single penny from her. Is she correct? Yes, minor you can't recover. She will be major on 1st Jan 2025. Not yet. And only after that agreement can be ratified. Can she ratify? No. Explain by the ways whether Mittal will succeed in recovering the amount. By filing a case against Paridhi, a minor, for recovery of outstanding amount with interest, can he recover? No. If it is for necessities, he can sue and recover from the property. By filing a case against Ram, father, can you recover? No, you can't recover from guardian. Minor cannot bind the guardian unless the guardian gave the consent. Or if it's for necessities, you can recover from the property of minor. By filing case against Paridhi, a minor, for recovering after she attains majority, no. No ratification after attaining. But the question is bigger. But while reading the question, if you knew what could be the question. Are you following, guys? Good. This is our latest December 23 RTP question. Some answers, those who are watching, I'm telling you, some you might not get the answer instantly. It's okay. You are learning now. Are you following, guys? Clear? Laptop necessity or not depends on your perception and assumption you give. Okay. Now, laptop is a necessity 5 years back or 10 years back. I won't say it's necessity. But today, phone, I will say it becomes a necessity. Everybody needs it for some purpose. Basic calling, etc. But laptop, again, depends. Correct? Are you following, guys? Those are assumption you take. But based on the facts of question, they have not given any hint. It's a necessity here. Next. Rohan found a wallet in a restaurant. Say, I am solving this RTP along with you. I have not seen the answers. Okay. Other questions I know the answers because they are old RTPs. This is the first time I am solving. Okay. We will go check the answers also. Rohan found a wallet in a restaurant. He inquired all the customers present there, but the true owner could not be. What are you talking about? Finder of lost goods. He handed over the same to the manager of the to keep the wallet till the true owner is. After a week, Rohan went back to the restaurant to inquire about the manager refused to return it to the saying it did not belong to him. In light of contract, can Rohan recover the wallet from manager? Because we saw he handed it over to the manager of the restaurant to keep the wallet till the true owner is found. Now he handed it over. Rohan has the right to keep the lost goods until the true owner is found. Okay. Let's check the answers also. We'll keep this in a different page. Just to cross check so that we don't go wrong. Okay. First, Sheetal they can terminate. Second case, management informs, so they cannot rescind they can claim damages. Minor cannot bind the guardian, no ratification. Mittal will not succeed in recovering the amount. Responsibility of finder of lost goods. Management must return the wallet to Rohan. Since Rohan is entitled to retain the wallet against everybody except the true owner. Are you following, guys? Clear? Are you understanding? Are you easily getting the answers? Next. Now this question, fourth one. Can you try to do it by yourself quickly? I'll leave it for just 15 seconds here. Okay, follow guys. This question talks about appropriation of 2 years back in 2021 when they asked this in exam. It was a 6 mark question, a theory question. What is appropriation of payments? Now they're asking a case study question. But a similar sum we already did in the class where there was a question ABC, Irfana, do you remember that guys? That was framed long back. Similar question, different numbers. Let's apply guys. Sohan is a wealthy individual, provided loan of 80,000 to Mr. Mukesh on 26th Feb 2021. What is the first loan? 26th Feb 2021, which is for 80,000. Keep the facts. The borrower, Mr. Mukesh, asked for a further loan of 1,50,000. Sohan agreed but provided the loan in different dates. He provided 1 lakh on 28th Feb 2021, second loan. Different dates means separate loan based on time, and remaining 50 on 3rd March 2021. So basically 3 dates, 26th Feb, 28th Feb, 3rd March, all same year, hardly within a week. On 10th March, Mukesh, while paying off, what is the amount? 80,000? 1 lakh? Mukesh, while paying off 75,000 to Sohan, insisted that the lender should adjust the 50,000 towards the loan taken on 3rd March and the balance on the loan taken on 26th Feb. So he wants to adjust with the first and the third loan. The 75,000 he wants to adjust fully with the third loan, balance 25,000 with the first 80,000 loan. Sohan objected to the agreement and asked the borrower to adjust in order of time. Sohan, who gave the loan, is saying, no, I won't agree for this. He's saying you first adjust the old loan. Who is correct here? Mukesh is always correct here. Because first right is with the borrower. He can tell which to adjust. Then only, if he is silent only, Sohan decides. Now I know the answer, but let's read the question. Whether contention of Mukesh is correct? Yes. What would be the answer if the borrower does not insist on such order of prepayment? Then Sohan can do whatever he wants. What would be the mode of adjustment in case both are silent? Order of time. Basically the same 3 points only of appropriation of payments. He's asking in case study. So you have to write with the numbers. Are you following guys? Clear? Presentation, I'll come to it. Let's do about 10-15 questions. I will again come and brief. So same thing. Let's go look at the answer. Appropriation of payments. They explain what is appropriation of payments and the 3 cases of appropriation of payments. Look at the presentation of ICA guys. That should be our benchmark. First they are telling what is appropriation of payments. Then they are telling the provision of 3 provisions, and then sum is over. Here they have done provision, then can you see a small analysis? Again provision and then analysis. Provision and then small analysis and conclusion. Are you following guys? This is a 6-mark question. Alternatively, you can write the full 3 provisions and the analysis conclusion 3 points. It's fine. This is not the only way to do it. But what is there here should be there in the answer. Are you following guys? Clear? Done. I'll come to presentation again, detail later. Let's do next one. Whether the following agreements are valid or void as per Indian Contract Act. Anybody already finished December 23 RTP? No one. Why? It's been released 2 months back. 1 month back they released. It's okay. Anybody watching the recording already finished the RTP? Little bit you can fast forward for the next balance 5 RTPs and past exam and own questions. Now, whether the following are valid or void. These are all 6-mark question, 2 each, or it can be 3-mark question, 1 each, with explanation or without explanation. Where 2 courts have jurisdiction to try a suit, the agreement between the parties that the suit will be filed in one of those courts alone and not in the other. Is it valid? It's valid. What they're saying, if there's an issue for 2 courts, like which court to file, parties already have an agreement which court to file. It's valid. What is void is, you should not file a case. Agreement and restraint of legal proceedings. X offers to sell his Maruti car to Y. Y believes X has only Wagoner but agrees to buy it. What is this? Mistake. Bilateral or unilateral? X offers to sell his Maruti car to Y. Y believes that X has only Wagoner but agrees to buy it. Whose mistake? Y believes that X has only Wagoner. Both means it becomes void. 1% means valid. We'll check the assumption they have taken. Then last, X, a physician and surgeon, employs Y as an assistant for a salary of 75,000 per month for a period of 2 years, and Y agrees not to practice as a surgeon and physician during these. What is the agreement in? Restraint of trade, but it has some exceptions. Service agreements, those exceptions. Let's go check our answer. First case is valid. Correct, guys? Agreement and restraint of legal proceedings. It's valid because you are still allowed to file a case. It's about which court. Second is void. Treated as void because of mistake of fact as well as absent of consent. Here they have taken as void because two parties are thinking about two different subject matter. So it's bilateral mistake. See, if it's unilateral mistake, it is valid. Here it is a bilateral mistake. Okay. And last one, agreement and restraint of trade is void, but it has an exception. Which one, guys? Agreement by service. You remember discussing, guys, agreement and restraint of trade is void, but it has some exceptions. Service agreement, some judicial case, we saw that partnership. Do you remember that, guys? Sole selling agreement, those kind of things. Are you following? Can you connect with the book, guys? Is there anything outside the book so far? It's about application of concepts. Okay. Done. Oh, sorry. Yeah. Next, we'll stop with Contract Act of RTP. Sixth question. Mr. Seth, an industrialist, has been fighting a long drawn litigation with Raman and other industrialists. Both are fighting. Okay, fine. To support this legal campaign, Mr. Seth enlists the service of Mr. X, a legal expert, stating amount of 5 lakh would be paid if X does not take up the case of Raman. X agrees, but at the end of litigation, Seth refused to pay. Describe whether X can recover the amount. What is happening? Two people are fighting, guys. X and, let's say, Seth and Raman are fighting. Top advocate, just know a while back in our previous session we were talking about advocates. There are some advocates where if an advocate comes to the court itself, the court will shiver. There are like that. They charge 40 lakhs per hour. Some people charge 50 lakhs per hour. 1 hour I come. So when the advocate comes in, the judge itself will get up and tell, sir, please have a seat. There are some people like that. No, I'm not talking about Amitabh Bachchan or Ajit in movie. The real advocate. Okay. Now, so when these advocates come, so why? That's for what Seth is telling. That superior advocate X, you please don't take the case. If you take the case, I'm going to lose, sir. For that, I will take you. I'll pay you 5 lakhs. Non-compete fee. Not non-compete fee. Agreement and restraint of legal proceedings. Don't. See, basically, I'm asking somebody not to practice. Agreement not to do something. Now, later, he did not take up the case. Seth did not pay. Can I recover? No, you cannot. The other party cannot recover. Answer if you see. Agreement by which obtained from legal agreement and restraint of trade is void. You cannot ask someone not to do something. In instant case, Seth is in litigation. X agrees, but then he did refuse to pay. Agreement is void, and hence you cannot recover the amount promised by Seth. Let me explain again, guys. Agreement and restraint of trade is void. Meaning, I'll give a simple example. If somebody pays me, don't take class for next 1 month. Here, 5,000 rupees. I can take the money and still continue to take class. Or if I don't take class, if they don't pay, I can't sue them. because nobody can stop me from doing the business which I want to do, which is legal. Agreement and restraint of trade is void. Are you following, guys? Getting the answers? Is this speed fine? How many of you feel, sir, continue in the speed? Okay. How many of you slow down? How many of you speed up? Fine. So we'll continue. YouTube, I'm not asking you. If you want to speed up now, you put 1.5 or 1.25. Slow down means you put 0.75. Those who are watching recording. Okay. Next, whether the consequence of destruction of specified goods before making contract and after agreement to sell under Sale of Goods Act. What happens? What are the consequence of destruction of goods before making contract and after agreement to sell? Unit 1 of Sale of Goods Act, contract becomes void if subject matter is destroyed not because of the fault of the buyer or seller. Do you remember this, guys? Okay. Now look at Sale of Goods Act again. What are the implied conditions in sale by sample and what are the implied warranties under the act? What are the implied warranties? Warranty as to undisturbed possession, non-existence of encumbrances, disclosure of dangerous nature of goods, quality of specified trade usage. What are the implied conditions in sale by sample? You know, you should taste the sample or you should take the sample. Sample bulk should meet with the sample, then otherwise the contract you can be cancelled or you can sue for damages. Implied condition. Clear, guys? Next, question 9. Read and see if you have done this somewhere. Yes. So go through others. Go through. Is it same thing, guys? Same question what we did earlier, but here it is. Blue stone. In the different RTP it was some red stone, but concept is same. Read the whole question in 10 seconds, give me the answer. Whether Shubhangani can recover the amount from jeweler? Yes. What would be your answer if jeweler says he cannot change the decision but charge extra? No. Can he charge extra, guys? No, I will not pay for it. What is the concept being tested? Agreement to sell. When there is an agreement to sell with certain conditions, sale ownership will be transferred only after those conditions are met. Here conditions are not satisfied, so ownership is not transferred. Another answer we also spoke about is quality or fitness. Implied condition, quality or fitness. Seller deals in those goods, specified description. Let's quickly go check the answer. Sale by sample, yes. Okay. Yeah, that's about it. Agreement to sell. Able to follow, guys. You can write quality or fitness along with this additional point. Both are correct. I will show you suggested answers where they give alternative answers. Next. 9 is done. Next question, guys. State what are the essential elements involved in sale of unascertained goods. What there are points, guys. Ascertain the goods with the consent of buyer or without the consent of buyer. Get consent before later. Unconditional appropriation. Do you remember those points, guys? These points. We wrote the same points. You have to replicate those points as it is. Do you remember this? Hello, guys. Clear, you have to remember this. Next. I missed 7, no? 7th answer. See, if you want to check any specific answers, I will give the PDF because of 80 questions. But this I will show you because you asked this one. Unit 1 of Sale of Goods Act, Section 7(8). In both the cases, contract becomes void because goods are destroyed not because any fault of the seller or buyer, not with the knowledge of the seller or buyer. Following, guys, it's in Unit 1 of Sale of Goods Act. Next. Let's finish off the RTP if we can go. 10 is done. We have 11 and then 12, 13, 14. Yeah, we can do it. Now we'll come in reverse, guys. Okay, just for the sake of it, for changing the flow. This question also we solved. Narendra Motors Limited is a government company. Shah Auto is a company having this. Those who are watching recording, just pause and see. What's the answer, guys? Whether Shah Auto is a government company? Yes. Now exam, if they give again same question, without reading, don't tell yes. I saw this in class. They might change the facts. But why is it a government company? Quickly, Shah Auto is a subsidiary. Narendra Motors has 5,05,000 shares out of 10 lakh, which is more than 50%. So, a subsidiary company which is a subsidiary of a government company is deemed to be a government company. Where students make mistake is, sir, 51%, no sir. 51% is for government company. This is a subsidiary of a government company. So, subsidiary I would check only more than half of total voting power. Already it's government company. Clear? Companies Act. Next. Go through question 19. Tell me, give me the answer. Go through, guys. Answer. Anybody got it? When a question like this comes in exam, you cannot keep staring at it. You have to draw the diagram. Narendra Motors Limited, I didn't draw because we have done a similar question. The minute you draw, by the time you finish the drawing, you will get the answer. Don't draw in the full page. Somewhere in the side, you can draw. Okay. BC Private Limited is and its subsidiary. So, BC and its subsidiary KL are holding 90 and 90,000 and 70,000 where, guys? In PQ. PQ has share capital of how much, guys? 3 lakhs. The question is whether PQ is subsidiary of BC. Collectively they have 90,000 plus how much? 1 lakh out of 3 lakhs, which is more than half. Are you following? Second question, what would be your answer if KL, new company, or KL, is holding 1,60,000 shares in PQ when no shares are held by BC? What if KL is having 1.60 lakhs in PQ and BC has nothing? Still it becomes a subsidiary. Both cases subsidiary. It's question number. Let's cross check. No harm in cross checking. Definition. Both. Yes. Remains the same. Remains the same. Are you following, guys? But the reason is different. Are you following? Because the definition has the word directly or indirectly or deemed to be subsidiary. Controls. Yeah, either on its own or together with one of more subsidiaries. Able to follow, guys? Okay. Come back. 19 also is done. 18. Describe the conditions under which LLP will be liable and not liable for acts of the partner. I gave you liability of partner, liability of LLP, right? Liability of partner, when he is liable, when he is not liable, and also in case of fraud, liability becomes, you can write that. But fraud is additional point, mainly write when he is liable and when he is not liable. Next. State whether the following is partnership or not. Two firms having 12 partners combined by an agreement into one firm. Yes. A and B co-owners agree to conduct the business in common for profit. Is it partnership? Co-ownership is not partnership. 17. We'll check the assumption they take. First, yes, they are a partnership. Second is, co-owners agree to conduct business in common for profit. Definition of partnership: agree to share profits from business. Here they are agreeing to share profits from business, so it becomes a partnership. Next, some individuals form an association in which each contributes 500 annually. Objective is to produce clothes and distribute clothes for free to. Is this partnership? No, charitable work. A and B co-owners share between themselves rent derived from piece of land. No. Can you see the difference from the previous point and this? No, they are not partnership. A and B buy commodity X and agree to sell the commodity with sharing the profits equally. Are they partnership? Yes. We'll come here. Third, no, because it's charitable. Fourth, no, it's a case of co-ownership. Last one, yes, because they're sharing profits. Are you following, guys? Now do you understand in class why we spent close to 40 minutes for just for definition of partnership and true test of partnership? Are you able to get the answer, guys? Harish? Yes? No? If you have doubts in, see, if you have doubts in the answer I'm giving you, ask. I'll explain. Last one, why is it a partnership? A and B buy commodity X. Agreement is there. Sell the commodity. That means they're doing the business together, sharing the profits equally. That's it. True test. They are not doing business. In piece of land, they are not doing business. They are joint owners. That business is missing. Got it? Following, guys. Feel free to ask your doubts. It could be doubt for anybody. Just ask. We'll be quick. Okay. Done. 2019, 18, 17 also is done. 16. Quickly read it, guys. Master na minor. Okay. Master means minor, guys. Don't take a different meaning. In one RTP itself, how many questions on minor? Contract Act, Partnership Act. Examiner for some reason likes minor questions. Follow, guys. Master X was introduced to the benefits of partnership for X, A, B, and so benefits of partnership with the consent of all the partners. After attaining majority, more than 6 months have elapsed. He failed to give a public notice as to whether he elected to become a partner or not. Later on, Mr. L supplier of material of to ABC, filed a suit against ABC for recovery of the debt due in light of provisions. To what extent will X be liable if he failed to give public notice? Unlimited liability, as if he becomes a partner. If he has the knowledge, he should be aware that he is a partner, not just like that. The provision is from the date of majority or from when he is aware of he is a partner, you compute 6 months. Whether L can recover his debt from X if he is aware. 16. He failed to give public notice, he shall be partner and become personally liable. Here the assumption they are taking is he is aware. In light of provisions, he will be deemed to be partner and hence you can recover the loan. Are you following, guys? With reference to provisions of partnership, he is asking explain about insolvency. We know I gave those 4-point notes, same 4 points in book. Insolvency, from the date of order of insolvency, you stop to be a partner, all of them. Yeah, okay. We'll finish off this, then go to our questions. Is that fine, guys? Quickly. 14th question. Can you read quickly and give me the answer, guys? 14th one. I want you to try. Some I'm reading, some you have to read. Follow guys. Here a senior partner transferred his share to his son, but the other partners were not interested. The word not interested, he did not wish, whether he did not give consent. If he did not give consent, then he can't join. But here they are saying not interested. Let's say after joining, if Vikas felt after some time, Vikas who joined felt books of accounts is not good, turnover is not good, explain the rights of a transferee, transferring the interest to the other partners. What's the answer for that, guys? Right of transferee, section 29. Do you remember we had presentation on this topic? Go through provision. He cannot inspect with the other partner's consent, but a transfer by a partner of his interest in the firm, either absolute or mortgage, by creation of a charge, does not entitle the transfer during continuance of the firm to interfere in the conduct of the business or require accounts or to inspect the books of the firm, but entitles only to transfer or receive the share of. Here he has not joined as partner. What's his name? Vijaya. Vikas. Vikas, if he joins as partner, he can do all this. Here he has not joined as partner. The other partner only transferred his interest. His share of profits is transferred. So only thing he can do is get a share of profits. Section 29, right of transferee of partners' interest. Are you following, guys? No, here. Can Vikas be introduced if his father wants to retire? No. He can be introduced only if the other partners give a consent. Check the answer. Yeah. Subject to the provisions, Vikas can be introduced only with the consent of the other partners. Otherwise, you can't introduce unless there is an other agreement for that. Clear, guys? Any doubt there? Yes? Sure. Feel free to ask any doubts. If you have a different point, you can bring it up. High agreement is there in the class. Yes, doubt in the K-class. Sure. Okay. Sorry. Okay. He cannot inspect the books of accounts. Section 29, right of transfer of partner's interest. This concept is basically transferring share of profits, not the partnership itself. Are you following, guys? You can mark this as important because examiner has already tested this concept, but he is still not leaving. Again is testing. So question 14 of RTP, latest RTP, you check it. Okay. You have the answer, but this concept, guys, section 29, right of transferee. Okay. Next. This, let's be quick, guys. Direct questions. What do you mean by partnership of fixed period? You know better than me. Whether the continuing guarantee can be revoked under Partnership Act? Yes. Continuing guarantee can be revoked. Continuing guarantee, section 38, continuing guarantee in respect of transfer of firms can be revoked at the time of death, retirement, or whenever there is a change in constitution of partnership. Do you remember this, guys? Clear? Harita took the presentation of this continuing guarantee. This concept also you can mark it as important. What do you mean by goodwill as per the provisions of partnership? It's a goodwill that it's basically property of the firm. So goodwill has not been defined, but it's regarded as what, guys? When we discuss property of the firm, I told you whatever comes in balance sheet, intangible asset also is a part of balance sheet. So it's a goodwill. Goodwill may be defined as value of reputation of business. You know better than me what is goodwill. Correct? Are you following, guys? Do you have the super profits, this and all? Accounts. That's it. Next question. Go through question 12. Give me the answer, guys. By the time you read the question, you should know the answer. What concept, guys? Right of stoppage in transit. I can stop the goods in transit if buyer becomes insolvent and the goods have not yet reached the buyer. Here, how much I can stop? 450 bags can be stopped because how much he received? 50. Go to question 12. That should be the answer. Let's cross check. Yeah, 450 bags are in transit. So the official receiver cannot claim the bags because 450 are in transit. Seller, who is the seller? Ravi can get the bag. Are you following, guys? Because here Ravi, being still unpaid, stops the bag in transit. But what if official receiver Ravi Tushar took 50, official receiver took 450. What can Ravi do? Nothing. He has to sue for price. Are you understanding, guys? Next, last question. With this, our December 23 RTP comes to an end. Big question. It looks big, but you have to read it, guys. Try to answer. I hope online you can see visible. Read it, guys. Can I have somebody online read it? Bevashti, can you read the question quickly, fast?
Sir, can you hear me?
Yes.
Yes, sir.
I think there's some disturbance from your end, Bevashti. No problem. Try to fix it. Next question we'll read. Okay. There's some.
Sir, is it okay now? I switched off the fan.
Yeah, better. You can read it fast. Yeah.
Yes, sir. Mrs. Kanchan went to the local rice and wheat wholesale shop and asked for 100 kg of basmati rice. The shopkeeper quoted the price was same as 125 rupees per kg, to which she agreed. Mrs. Kanchan insisted that she would like to see the sample of what would be provided to her by the shopkeeper before she agreed upon the such purchase. The shopkeeper showed a bowl of rice as sample. The sample exactly corresponded to the entire lot. Mrs. Kanchan examined the sample casually without noticing the fact that even though the sample was that of basmati rice, but it contains mix of long and short grains. The cook, on opening the bags, complained that the dish, if prepared with rice, would not taste the same, as the quality of rice was not a requirement of the dish. Now Mrs. Kanchan want to file a suit of fraud against the seller, alleging him of selling a mix of good and cheap quality rice. Will he be successful? Decide the fate of the case and opinion to open to Mrs. Kanchan for grievance and redressals as per the provision of Sale of Goods Act 1930. What would be your answer in case Mrs. Kanchan specified her exact requirement as to length of price?
Answer, guys. What is happening? She wanted to buy some rice. She asked for sample. Shopkeeper gave a sample. Sample exactly corresponded to the entire lot. Kanchan examined the sample casually without noticing. Even though the sample was of basmati rice, it contained mix of short and long grains. Did she ask for basmati rice? Where is it given? Yeah. And asked for. So she asked for both description and sample. The cook on opening the bag contained dish if prepared the rice would not be taste. Okay, fine. Kanchan wants to file a suit because it did not meet the quality. Can she file under the doctrine of caveat emptor? Doctrine of caveat emptor says buyer has to be, but the exception is sale by. But sample means I should check the sample properly. Here the sample was not checked properly. What would be your answer if Kanchan specified her exact requirement as to the length of rice? Then she can sue the seller because she has given the description. I want the exact length of rice. Are you following, guys? Understanding? Let's check the answer for 11. First three cases. First, we are talking about sample provisions. Buyer should have opportunity of think sample should meet to the bulk. In the instant case, Kanchan does not have the option for her to suit for her grievance because sample says sample should meet with the bulk. Sample is small and long rice. It's meeting with the bulk. In case Kanchan specified her exact requirements, that means the implied condition, it should match with this description. If not, seller will be held liable. Are you able to follow, guys? Beautiful question, how they have drafted. Exception, guys, exception. Because I didn't see the sample properly. But why are you able to get the answer, guys? Most people will tell, no, 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 sample should match with the bulk. Yes, sample is matching with the bulk. Here, for me, basmati rice is short and long, seller. No description. That's why second point. Are you following, guys? Clear? Understanding? Don't try to connect your knowledge of basmati rice with this. Go with what is given in the question. With this, we have successfully completed December 23 RPP. Were you able to get answers for all the questions? How many of you? Sir, 80 to 90% of questions I got answers. Fine. Good. Next. I'll go to a few own questions now. And then we'll come to these last 58 questions. We'll keep that to the last. Fine. Okay. Fine. Just some random own questions. Random frame. Don't look at the facts of the, look at the concept. Try to connect with which law. Let's see. First one. Darshit and Darsh were looking to start working out and bring a fitness regime for themselves. Ronak, who was their friend, offered to coach them only for 2,000 for both of them for a period of 3 months. The usual price that Ronak charges is 10,000 for 3 months, but he's giving them a discount of heavy discount. After 1 month, Ronak stopped taking the classes because both Darsh and Darshit were not attending the classes seriously. Hence, Ronak lost the interest in taking classes. Darshit now sues Ronak for specific performance. Complete the class. Whether I'm there or not, you come and take the class. Ronak tells Darshit to pay the balance of 8,000 and says the payment of 2,000 is not fair. Being the judge, what's your decision? Hello? You understood question, huh? Guys, answer. Now, simple. Is there a valid contract? Go with contract act. Is there a valid contract between the gym coach, Ronak, and other parties? Yes. Is the contract having consideration? How much? I don't care how much I charge outside. Is there consideration here? Consideration need not be adequate. So consideration also is there. So contract is for 3 months. Promise chapter says performance. It has to be performed. He's not performing for 3 months. It becomes a breach of contract. Can Darshit sue? Yes, that's all. Who asked you to offer for 2,000? Are you understanding, guys? Clear. If you make a promise, contract is valid, go and perform. Getting it? Sure, 100%. How many of you got the same answer? Good. Others understood, guys. See, own questions. Whether this will come in exam, I don't know if my examiner has the copy to these questions. Made it 2 years back. But it's more than exam point of view. Are you able to think and connect with the concept? Because exam new question only will come. Next. Next. Yes, Sanjeev, read it fast. Tell me now. Yes, Harish, read it. Answer, guys. I ordered for some cosmetic products. They said 5 to 7 days. It came late. What happens to the contract? Contract becomes which concept? In unit 4, performance of a contract, time is essence. How many of you got time is essence? Good. Time is essence. We discussed where time is essence, it has to be delivered within the time. Where time is not essence, reasonable time. Here time is mentioned 5 to 7 days. I ordered on 17th November. Marriage is on which day? Almost 1 month. It should come before that. not after the month, after the marriage, sorry. Are you following, guys? So contract is what? The concept of time is essence. Are you able to follow, guys? See, if I take existing RTP questions, everybody will know, sir, I've seen this so many times. This is like new thought, but connecting with the same concepts. Following, guys. Next. Yes, online. Okay, I'll read this. Dhanlakshmi purchased some parota from nearby restaurant and had the same for her dinner. The next day she fell sick and she realized it was because of the parota. She wanted to sue the restaurant. Can she sue them? If yes, will she will recover the amount? I will not tell which act. You tell which act. Sale of goods act, contract act, what? Sale of, okay, if it's sale of goods act, what answer? Implied condition as to mercantability and wholesomeness. Wholesomeness, the fit should fit for the purpose, correct? More than mercantability, whenever food products come, it is what, guys? Wholesomeness. Are you following? Are you understanding, guys? Hello? Okay, are you following, everybody? Actually, this happened. Dhanlakshmi was a student in one of the previous batch. She didn't come to class for 3 days. I asked what happened. Sir, I ate parota and she fell sick. Okay, question. We'll add it. Okay. Following, guys. Then, able to understand quality as to mercantability and wholesomeness. Next. Next batch, I will add questions from Leo movie. I'm thinking what all I can frame and put it into the, what to say, our syllabus. Fine. In the test, one of the tests you wrote, you would have seen question from Master movie. Have you seen that, guys? Okay, did you write the test like that? Hello? Those who wrote the test will know. I put question from Master movie. Initial class test. Okay, fine. Miss Jaya was a famous singer. She won the Indian Idol competition for the year 2022. Before the competition started, they promised to give her 10 lakh as cash reward if she wins the competition. After winning, she was given only 1 lakh. She wants to sue Indian Idol. Can she sue? Contract, I'll give clue. Indian contractor. Can she sue? It becomes what? Wager, price, and that what is not a wager, what is a wager? There is a limit of how much? 1,000 rupees. Do you remember, guys? Price is more than 1,000. Are you following, guys? Clear? Jia was also actually a student. She was on Indian Idol before foundation. Okay. Done, guys. Don't go search on Instagram, but you will find if you search. Done. Able to follow, guys? 1,000, no, they didn't amend it. Why? Doctrine of contemporary exposure. Leave it. Come back. Are you able to follow, guys? I will anyway share the answer for all these questions in PDF. But in the next, in this 2.5 hours discussion, we will finish maximum questions. Next. Yes. Saket and Surya formed an organization called Flat Earth LLP. They claim that the earth is flat and the government is hiding from the entire world. They have scientific evidence, but everyone are making jokes out of them. Their faces were all over the social media. They were emotionally embarrassed and hence it hurt their ego. For this purpose, they wanted to take revenge and they started to hurt everyone. They started, what did they start? Make a mockery. Prepared to cancel the LLP. Cancel the registration. Is it allowed? Yes. Closing of LLP affecting the sovereignty and interest of India. Do you remember, guys? Hello, LLP winding up provisions. See, don't expect this kind of concept question in exam. Focus on the provision which I am trying to connect. Are you following, guys? Okay. Yes. Next one. Online. Can I have? Yes. Niranjana, read question 6 fast. Online students, be ready, guys. When I ask you to read, read it.
Mr. Vikram and Mr. Bala and Mr. Santosh are factors in LLP called time loop LLP. The objective of the LLP is to help people finance their time better. Mr. Vikram had taken a loan of rupees 20 lakhs in the name of the LLP in 2019. In the year 2021, the LLP became bankrupt and hence they had to dissolve. Upon dissolution, the LLP had only rupees 11 lakhs left to pay the loan. Hence, the bank asked Mr. Vikram and the other partners to bear the loss of rupees 9 lakhs. Address the partners as to how much of them should contribute, assuming profit sharing ratio is equal.
Simple guys, loan is for 20 lakhs. They paid only. So balances. How much should they share? This is LLP guys, nothing. Only partnership act they have to share equally. 9 lakhs lost to 3 lakhs each. How many of you thought 3 lakhs each guys? Gone. This is not partnership. This is what guys? LLP. Liability is limited. Are you following guys? If alone the exam question paper comes to my hand, gone everybody are. Okay. Yes. The assembly hurt everyone who made a mock out of them against the interest of India, assuming they're going to like do against sovereignty of India. Able to follow guys? I use the word LLP. First lane LLP, second lane LLP, third lane LLP, fourth lane LLP, 5, 6. Nobody saw LLP. We'll share the. Able to follow guys? Clear? Understood? Do you want to continue these questions or go to our last 5 RTPs? Continue this. Okay, fine. Next, in the month of April, because of the pandemic, Apollo Pharmacy started selling sanitizer and masks for a very high price. For instance, one mask was sold for 100 and one bottle of 100 ml sanitizer was sold for 300 in many parts of the country. One of the customers wanted to sue Apollo as he was selling masks for unreasonable price. Can he file a case? Anywhere in Contract Act or Sale of Goods Act, did we mention that you should not sell for higher price? If you want, you buy. Are you following guys? What price? The seller only will decide. Will he succeed? No. Are you following? Don't write during COVID how he will file case. How will he go to court? Don't write all of that. The concept here is, what's the concept guys? Price. Are you following guys? Price can be any price which the seller decides. Anywhere in the law, take a moment, think. Did we talk about unreasonable price? Then why are you trying to sue? Are you following guys? Theater PVR charges 100 rupees for water bottle, 500 rupees for popcorn. Unreasonable price. Are you paying and eating guys? Every time I go for a movie, my interval cost is 2 times ticket cost. Okay. Next question. Online, can I have? Again, Niranjana, please read it for us fast. Shh, guys, read it fast, quickly. Niranjana.
Pizzas from Domino's Pizza in the Domino's app. She made the payment using a credit card and the order was confirmed by Domino's. Domino's handed over the order to the delivery agent. During delivery, Domino's realized that the payment actually failed and they asked Ms. Shrutika to make the payment away. She said that her money is debited. Domino's claimed that the money will be refunded within 5 to 7 business days. Mrs. Shrutika said she will not pay until she gets the refund again. Hence, Domino's asked the delivery person not to deliver the food. Domino's said that they exercise the right of stoppage in transit. Shrutika seeks your advice as to whether what Domino's is right and whether the contract is valid.
Clue is Sale of Goods Act. That's the maximum clue I can give. What happened in the question? Shrutika ordered pizza. She made payment. Order was confirmed by Domino's. After this, Domino's handed over the pizza to delivery agent. During delivery, Domino's realized that payment actually failed. So they asked them not to deliver using the right of stoppage in. When can you exercise right of stoppage in transit? Only if Shrutika becomes. Here, contract is made. Ownership is already transferred. Yes, this is sale of what? Goods to be put into deliverable state. So pizza is made and it's put into deliverable state and informed to the buyer because order is confirmed by Domino's, order on the way. That means ownership is already transferred. You cannot exercise the right of reservation after this. Are you following guys? Are you understanding? Yes, Harish, doubt? Clear? Understanding guys? Follow? Yeah. My whole intention over here again is, are you able to connect with the concept? Day before exam, don't sit down and read these 20 questions. I will tell you, this all will not come in exam guys. It's for you to improve your thinking, own questions. Now for example, you buy so many scanners, correct? Law scanner, this big, whatever. Even if you solve 1000 questions, they are all past exam questions. So you will think only within the same box. These questions are to help you think outside the box but get the same answer. Are you following, guys? Clear? Next. Yes, go ahead. We will read. Who will read? Online. Sindhil, if I call also, he is not replying, but is attending every class, so that's good. Yes. Bevashni, can you read quickly question 9? I think by the time I ask Bevashni, she has to turn the fan off. Yeah, read it. Yes. Sorry, but yeah, please go ahead.
It's okay, sir.
Yeah.
Ms. Bharata has joined Tata Company post her qualification, and to receive her salary, she had to choose between Yes Bank or ICICI Bank. She opened the bank account with Yes Bank since the bank promised her a diamond debit card and a platinum credit card for lifetime validity without any charges. After 2 years of bank started leaving charges. Hence, she mailed the bank about the same. The bank replied saying the bank has now changed the policy and it is same for everyone. Bharata, feeling cheated, filed a suit against the bank claiming specific performance. The bank agreed to pay her rupees 10,000 as damages. However, she insisted she need the bank to give her debit and credit card without charges. Advice being a judge.
So basically, Brahda finished. She joined a company. She took one bank. Bank promised lifetime free credit card. Now they are putting charges. Can she sue them? Because there is a promise made. They are breaching the promise. She can sue for damages or she can sue for specific performance. Give me the card for lifetime validity. Are you following, guys? Now Brahda is currently in CA final. When the question was done, she was in foundation. Okay. Able to follow which movie, guys? Many movies. Inspiration, credit card. Okay. Done. They have changed the policy, but they have promised something. So Brother can choose either sue for damages or sue for specific performance. She took the card because of a promise made up. So she can choose her remedy when she has multiple choices. Okay. So what if bank intimates? You joined the class. I told full class is offline. You came for offline class. After you joined, I'm intimating from now remaining 100 hours recording you watch. Will you be okay? That's it. Okay. Fine. Miss Prisha moved to Mumbai recently after joining her first job with Aditya Birla Group. Just to talk about this, after you clear CA, if you clear in the first attempt, there are some companies who take only first attempt students in CA final. One is Aditya Birla Group. They ITC is another company. Your annual pay starts with 24 lakhs per annum, 2 lakhs per month. Aditya Birla Group, that's the minimum pay today. But by the time you clear, it can become higher, inflation, all of that. Able to follow, guys. So she moved to Mumbai. Of course, if you join Aditya Birla Group, you have to move to Mumbai. They will give you 24 lakhs plus allowances, which comes to close to 30 lakhs for first job, guys. You are 21 years old, earning 30 lakhs. Sir, I'm Instagram influencer, sir. I'm earning 30 lakhs per week. Not everybody can get Instagram influencers real views. So follow, come back. She paid a monthly rent of 45,000 for a fully furnished apartment and pays additionally 5,000 as maintenance. Every day when she woke up, she found 2 packets of milk near her door. This we discussed in class. Hence started using it as part of the maintenance. After 2 months, milkman comes to collect it from for rupees 5,000 for the milk delivered in last 2 months. She says she will not pay the same as she already paid for it. Milkman says he has been delivering to the same house for the last 10 years. He was not aware the tenant have changed and hence he says he's entitled to claim the money. Should Prisha make the payment for that? Yes or no? Which contract? Quasi contract. Which one? Obligation of a person enjoying benefits of a non-gratuitous act. How many of you got that concept before I told? Good. How many of you understanding now? Harish Purilia. Done, able to follow, guys? Clear? It's for something else. See, if you see milk over there, Will you not want to check if it's part of the maintenance? Who is giving it? Will you just take it and drink? Are you following, guys? Understanding? Then I will come to your house. I'll keep everything near the door every day. Will you keep eating that, guys? You have to check. That's what everyone does. That's what the law is. Common sense. I told you. Apply common sense. These answers. Forget contract act, guys. No, forget contract act. Imagine today is the first day of your foundation class. I asked you this question. Will your answer change? No, that's only quasi contract. Correct? Or it's just basic common sense answer. Everything else, this ICICI Bank, common sense. Previous question. Pizza, is it common sense? This okay, it's little technical, but majority Apollo Pharmacy is common sense. Everything is common sense if you just look in that angle. Now, Sakshi and Vinita went to watch a movie in PVR cinemas. Within the first 10 minutes, the movie they realized was they came for the wrong movie as it was terribly boring. I'm not saying movie name, guys, but just putting it. So they came out of the theater and asked for a refund under implied condition. Warranty as to quality of fitness by usage of trade. Will they succeed in claiming for refund? Why? Which act is this? Sale of movie is what? So not applicable, not in syllabus. Are you following, guys? How many of you got that service? Very few. Intentionally kept the question. If it was good, you ate popcorn in PVR, not of good quality. You can claim for refund. How many times when you eat buy food in interval, sometimes if food is not good, you can claim for refund. What I will do, first I will get the popcorn, I will eat, again I will go ask for refill. He will tell, no sir, we can't refund it. Please, please. I'll ask 2 times. He will give free refill. Then I'll take it and go back and say. Now, just joking, guys. You try it out if you see if they give or not. Depends on the theater, guys. Depends on theater. Some good theaters will do it. PVR will not do. Hello. Leave it. Ignore. Fine. So here we are discussing about service. Sale of goods act is not applicable. Principle of implied quality is not there. Are you all following, guys? Hello. Upendra following. Next. Mr. Sharan is a beneficial partner in the firm RCBN from the age of 11. He was not aware that he is a beneficial partner. Oh, he was aware that is a beneficial partner when in his 17th birthday. He turned 18 years on 20th November 2021. On 31st December, he communicated with other partners that he does not want to continue as a partner of the firm. On 7th Jan, he changed his mind and gave a public notice that he wants to continue as a partner of the firm. The other partner said he cannot change his decision. Comment. Can he change the decision? What is the law telling? Which decision is valid? When you give a public notice. The decision is valid when you give a public notice. Me changing is fine as long as you have not given a public notice. But before he changed, if the other partners gave a public notice, then it's different. Are you following, guys? Are you understanding? Hello? Clear? Are you getting it, guys? Okay. Here I am discussing the concept of public notice. It's not about notice to other partners. In real life, it won't happen like that because other partners they will immediately give public notice. But question. Fine. Next, online. Somebody online who can read it loudly. Fine, let me read it. Danu and Vishnu together started a business of a car wash. They hired fully automated equipment from Germany and installed the first fully automated car wash in Chennai. Have you seen these machines? Car will go inside, they'll wash. You will see in so many all these English movies or comedy series you will see. The name of the firm was called Auto Clean and Co. Kashif took his car to the car wash and asked Danu to wash the car and also do an end-to-end service, for which Danu quoted a price of 20,000 and told it will take 5 days for the full service. Danu completed the service in 3 days, but Kashif mentioned that he can come out only after 5 days to collect the car. During this time, Vishnu gave the contract service car on hire to his friend Surendran for 1000 rupees per day without the knowledge of using the asset which belonged to the firm. Vishnu earned some money. Kashif was not aware of this fact and hence took delivery of the car and left. Danu finds this later and asks Vishnu to give him 50% of the personal profits made. Vishnu shares the same with Danu. After a few years, Vishnu gets enlightened and realizes his mistake. He wants to correct the same. What should he do legally to correct the same, guys? Understood the question of first. Who are the partners? Danu and they took a car for car wash. By the time customer can come back, they gave that car to Surendran and earned some money. Who did that work? Vishnu. Can I use firm's property for personal use? Remember section 27, liability of partners. Liability of partners in third point I would have told you in the class. Firm's property misapplied by partners. That gold example, all of that car wash example, remember guys, firm's property misapplied by, then partner should compensate the third party for any loss. Here third party Surendran did not get any loss, but partner Vishnu made personal profits. So whenever you make personal profits, you have to give it to the firm or do it with the consent of the firm. Are you able to follow, guys? Now after few years Vishnu gets enlightened, realizes his mistake. What should he do legally to correct the same? Amend the deed to say personal profits can be done, or if you make personal profits, share between the partners. Here I am testing only two concepts. Can I make personal profits? No. If you make, you should make with the consent of the firm. Otherwise, if you make without consent of the firm, give it back to the firm. Second concept, liability of partners. When you misapply firm asset, liability of partners to the third party. Following, guys, that's about it. No retrospective change. No retrospective change, only for the future. Okay. Now over here, you have to, over here, the third party use of the personal profit should be returned back to the firm and the parties. That's the way you can correct it. Are you following, guys? That's all. Next. Quickly read the question 14, guys. We have totally, I think, 20 questions, sir. 20, how many, guys? 20. We'll finish this also and then go to the last one. Quickly, guys. Yes, read it by yourself. Answer, guys. Go through, guys. I'll give clue. We are discussing Indian Partnership Act. Answer, guys. I'll give another clue. Unit 3 of Indian Partnership Act. Now follow, guys. Once the firm is dissolved, the partners do still have the power. Yes. Do you remember consequence of dissolution? Till the winding up, they can do those acts which are necessary for the purpose of closing down the firm. So here, firm is already dissolved. Partners don't have, as they are saying, cameraman said, no, cameraman is not right. The firm, would you justify the statement of cameraman? No. After dissolution till winding up, partners have the power to do those acts which are necessary for purpose of winding up. Consequence of dissolution, first point. Next. Are you following? Is any doubts? Please ask. Venkatesh is the head chef in Chennai Accord Hotel. He has 10 assistants working under him. On 30th September, the team prepared meal for 500 foreign delegates who attended the wedding of Jay Shankar. After the wedding, it was realized the food to the extent of 50 plates were extra. It was disposed of as per the policy of the Star Hotel. Hence, one of the assistants, without the knowledge of the hotel, sold 30 plates of food to a different hotel to serve to the guest at 200 per plate when the actual cost is 750 per plate of food. The third party says the contract of sale by assistants is void. What is it, guys? So, who is the employee here? Agent. We're discussing sale of goods. That is the sale void, guys. Yes, the person selling is not having the authority to sell. Two concepts. Title, transfer of title. You can transfer title only if you have the title, and second, if you put the concepts of agency over here, you don't have the authority to sell the goods. Are you following, guys? Clear? This is little more of a vague general question, not specifically picking any concept, but generally common sense. Is it void, guys? Yes. Yeah. Disposal means throwing it off. Even though he is doing a good deed where the food is getting wasted, he is using for something else. Law does not see what is good and what is wrong. It sees what is law. That's it. Are you following, guys? Next. Read the question, guys. 16th one. Go through. பார்ட்னர்ஷிப்ல எப்படி ஷேர் கேபிட்டல் வரும்? எங்க போட்டிருக்கு? மை ஃபால்ட். எங்க இருக்கு? Let's prepare the balance sheet, guys. Firm's assets is how much? 20 lakhs. Out of this, for Arav, how much is there? 8 lakhs. Rest of the partners, it is 12 lakhs. Capital of the firm. Yeah. Capital is 5 lakhs. Liabilities is 15 lakhs. Out of the total liabilities, Arav has taken he's taken loan to the extent of, so from this 15 lakhs, how much belongs to Arav? 7 lakhs. At the time of settlement, the assets of the firm were sold only for 6 lakhs. Rest of the assets of 12 lakhs is sold for 6 lakhs, and Arav's car was sold for 9 lakhs. Manner of settlement. Arav's 9 lakhs will first be used to pay his 7 lakhs. Then the balance 2 lakhs I will pay for the rest of the firm liability. Firm's 6 lakhs will be used for paying the firm's liabilities first. Then balance, if any, will go to the capital. Are you following, guys? In consequence of resolution, order of settlement, you are experts. Accounts, partnership, in school you would have studied resolution. But are you understanding, guys? The concept of testing here is partner's property will be first applied for partner's debt. Excess goes to firm's liability. Firm's asset will be first applied in firm's liability. Excess goes to all the other partners. Are you following, guys? Yes. The excess of 2 on the car will go to the liabilities. Got it? High, agree and clear. This was a doubt you had. Sorted. Next. Last, 3-4 questions. Next. Mr. R, Mr. C and B are partners in the firm RCB and Co. Mr. R has 70% share in the profits. Firm was incorporated in the year 2008, guys, 10 extra. In the year 2021, R has gone into coma as his firm was not performing up to expectations, and hence his son, Mr. V, had applied to the court for insolvency of the firm. The other partners, Mr. C and B, had claimed the firm cannot be dissolved as they wish to continue the firm, and only R can apply for insolvency and not his son. Are they right, guys? R is in coma. How will he apply for insolvency? Correct. Permanent incapacity to enter into a contract. In case of dissolution of firm with the intervention of the court. Do you remember those Surya movies we discussed? Unsound mind, permanent incapacity, affecting third party. So there, if one party is permanently incapable to enter into a contract, then somebody related to him can apply for what, guys? And insult. Are you able to follow, guys? Coma. Assume. Okay, even if unsound mind for the moment. Okay. Are you following, guys? See, question again, don't tell me, sir, why sir you're writing RCB not performing the expectation? That's not my meaning. I'm focusing on the concept, guys. Okay. Not trying to be biased for anybody, but if question came like that, coincidentally. Next. Fine. Question 18. Yeah. 18, guys. Yes. Quickly. Yes, Namrata, read it loudly.
They had a budget of 65 crores to shoot a new movie, for which they hired Mr. Simbu to act in the movie. Mr. Simbu, after initial understanding, decided not to act in the movie and he communicated the same to Mr. Shiva. Even before the shooting has begun and hence the production firm did not incur any expenses. Mr. Chiva informed Mr. Simbu as he did not inform. Simbu states that he already informed Shiva and it is the responsibility of Shiva to communicate the same to Chiva. Should Simbu communicate with both the partners that he does not
Communication to one partner is sufficient. Those who read online, read by yourself. Which concept? Section 23 and 24 of Partnership Act. Notice to one partner, effect of notice to an acting partner. Notice given to one partner is deemed as if the notice is given to the whole firm. Do you remember this, guys? Hello, how many of you got the answer before I told you? Good. Others? That side, Sweta didn't get the answer. Others? Able to get the answer? No. Preeti, Purida? Sure. Fine. See, again, the intention is not to take your confidence. It's for those who revised, if you're getting the answers, good. After studying for last 3 days, law also, I'm not getting the answers. That means you didn't study properly. And others, this is a revision for you, revising concepts. At least when I tell you, section 23-24, effect of notice to partner, one notice to one partner deemed for all partners. Are you recollecting the concept now? That's it. Next, question 19. X has a total share capital of 10 lakh shares of 10 each. 6 lakh shares of X are held by Y Limited and 3 lakhs are held by X are held by Z Limited. Balance is held by public. Explain the different relationships X is having. X Limited, guys, relationship with other companies. X Limited. Y is having 6 lakh and Z is having 3 lakhs and public. Now X is having 6 out of 10 lakhs, correct? How much? 60%. So between X and Y it becomes holding subsidiary. Z has an X, how much, guys? How much? 3 lakhs. So more than 20% it becomes an associate company. What is the relationship with public? Nothing. So subsidiary, associate, nothing, don't write it, just write subsidiary and associate. Are you following, guys? Clear? Last question. Who wants to read, guys? Yes, recording, live, can I have online? Prarthana, read question 20.
Miss Prisha purchased goods from Miss Prerna. Miss Prerna is a dealer in applying cultural produce. She's located in Punjab, India, and Prisha stays in Ahmedabad, Gujarat. Prisha offered for 10,000 liters of cow milk, and Prerna agreed to deliver the same.
During the course of transit, around 20 liters of milk was damaged due to travel and the milk was spoiled. Krisha says she would pay for 9,880 liters only. However, Prerna raised an invoice for 10,000 liters. Who should bear the loss for those 20 liters?
Yes, thank you, Pratna. Prisha is the buyer of goods. Prerna is the seller of goods. There is loss in transit. Who should bear? We discussed this. Hint is sale of goods act. Who should bear it, guys? I discussed in rules of delivery. We discussed short delivery means it will be with the seller. If it's short delivery, generally it's with the seller. If it's a long delivery, then it's with the buyer. Correct, guys? This is what delivery? Long delivery. So it should be with the reason logic is because it's long delivery, ordinary course of business. Now, if I'm sending for that long period, milk will get spoiled. If you send eggs in long transit, some goods, some eggs will break. Are you following, guys? With this, we are done with our own questions also, guys. Okay, super. Are you following, guys? Were they of any help, guys? Useful? No. Next batch, can we have that? Increase the number. Okay. You want to contribute for questions after exam? You can draft questions and send. We will add in the book. Okay. Fine. No break, guys. Unfortunately, no break. I'm just going to continue till 1:30, 1:40. Do maximum questions possible. And then we will wind up. Are you following, guys? Hello. Now moving on to case laws. Did we already discuss this case law? Few. I am not going to discuss all the 55. Now that our entire syllabus is over, I am going to go to these case laws. I am going to go to these 60 questions, guys. But before that, case laws, how to read the case law material that you guys have. There are totally 55 case laws in our study material. Okay. We have already finished all this. You have already studied this. How? Follow, guys. Randomly in this 55 case laws, can you tell me any 5 numbers? Whichever 5 numbers are here first. 10, 20, 25, 42, 55. Okay. So, these numbers I'm going to show you that we already finished. Let's go in reverse. First, okay, we'll go in order. 10 and 20. Let me go to 10. How to read the material is what I'm going to teach you. Okay. Go to 10. Don't read the name. Don't read the facts. Okay. What I want you to read and tell me if you already know this. Essentials of a valid acceptance. Acceptance must be communicated. Do you know this concept? What is this case law telling in my own words? Giving an acceptance without having prior knowledge of the offer does not amount to a valid contract, even if the acceptance is. Are you following, guys? Do you know this concept? To give acceptance, you should have knowledge of the offer. Are you following, guys? This concept, now you read the case. You don't even have to read. Where offer is made by intended offeree without the knowledge of the offer has been made, it cannot be deemed as an acceptance. Are you following, guys? Are you understand? This concept did we already study? You already studied or it's new? But in book it comes under a case law called some Bhagavan Das and some Girilal, whatever. I don't know the names. Why should I learn? You don't need case laws for foundation, inter also. Inter section numbers mandatory, foundation section numbers are optional. Okay. Now, come back. Next is 20. Like this, I'm going to do for these 5 cases randomly. 20. Immediately, don't go read that case law name, guys. I'm going to go to my notes, what I put. This case law is focusing on legal rules regarding consideration. Which rule? Consideration may move from promisee or, do you know the concept? Anybody can pay. In Indian law, consideration may be given by the promisee or in India, there is a possibility that consideration for a promise may not move from the promisee but third person who is not a party to the contract. Different from the English law, which is consideration must move from the promisee. For us, what is applicable? When you join class, who paid fees? Parents. Can I say no, you should pay the fees, parents should not pay? Consideration can come from the promisee or any other third party related to the promisee. Anybody, can be anybody. Are you following, guys? This concept is in the case law called Chinnaya versus Ramaya, facts of the case. This is there in the book. You go read that if you're bored. And then, which unit? Importance of case law. A. Yes, important. Page number also is given. Are you following, guys? So you can revise this quickly by just focusing on these two. உனக்கு புரியல, I'm not able to understand after reading this. Go read this. Still not understanding, go to the page number, read that concept, finish. Are you understanding, guys? Clear? Next number is 25. Yeah. Important for exam, that's it. Okay. Next concept. Mere silence is not. We learned this in Contract Act. Yes. The case law for this is Word versus Hobbes, and then a party to the contract is under no obligation to disclose the whole truth to the other party. Principle is caveat emptor. Same thing we saw. Are you following, guys? Okay. Next number 42 and 55. I'm just going random the numbers you guys gave. Highest case laws is in Contract Act. Okay. 42 came to Companies Act. Let me do partnership. In this material, partnership, we have only 3 case laws, guys. That's it. Only 3 case laws in full partnership. One is KD Kamath and Co. Supreme Court held that 2 conditions are essential to have a partnership. KD Kamath and Co. 2 conditions are essential. What is that? There should be an agreement to share the profits as well as true test of partnership. The business must be carried on by all or any of them acting for all. Mutual agency. Next. Do you remember this one, guys? Shantiranjan Das Gupta versus Dasre and Murzamul. We discussed in class. What is not a partnership if these 4 things are satisfied? Clear? And next one, Vishnu Chandra versus Chandrika Prasad. Last case law. Only 3 case laws in partnership. Retirement of a partner. If any partner wants to disassociate from the partnership, in a clause of the partnership deed which was being construed, then the expression clearly indicates in the event of retirement, the partnership will not come to an end. Where a partner wants to retire from the partnership firm does not lead to dissolution if the agreement provides for the same. This you can mark as important because in exam they already tested Shantaranjan Das Gupta and KD Kamath, but Vishnu Chandra they didn't. That's page 41. Case law 41, unit 2A, page 3.35. Okay, that you can mark that because they have not tested this case law yet. That too, it's a Supreme Court case, means it becomes important. Following, guys. Full Partnership Act, how many case laws we have? 3. So that's why I want to discuss that. Now let's go to which one? 40. Okay. This concept you tell me, guys, if you already know this or not. Separate legal entity. Yes. Concept of separate legal entity is tested here. Timber belonged to the company and hence should have been insured in the name of the company and not in the name of shareholder. What happened in the case? What happened? One guy started a company where he is selling timber. He took insurance in his name and not in the name of company. Insurance company told, we will not give you insurance because the timber was destroyed, because insurance is in, timber is in the name of company, insurance in the name of person. He told, no, I am me and company are same. Insurance company told, separate legal entity. Company is separate. You are separate. See, company has timber in company's name, but individual has the insurance in his name. Will he get insurance? No, because the concept of separate legal entity. Are you following, guys? Next number you guys chose was if I have timber, How can I approve for timber if I don't have? If you get insurance is about protecting you if you have that goods now or future. I can able to follow. Stock insurance. I don't have the stock, but I will take it. Up to that value, I'll be protected. Last case law in our book, someone chose 55. Do you remember this concept in Companies Act? Doctrine of indoor management. Exception to that is suspicion of. If you have a doubt, then this doctrine will not be. Where a transaction on the face of it looks very suspicious. Whether the companies had the power to enter into the transaction, the parties cannot take the defense on the concept of doctrine of indoor management to complete the transaction. The fact has to be checked whether company in real have the power to enter into such transaction. If you have suspicion, you have to check that. Are you following, guys? Now, do you know how to read this case law material? Everybody clear? Fine. Let's go to these questions. Last one. I will keep a cutoff of 1:30 and we wind up at 1:30, guys. So going back to our initial discussions, follow, guys. Own questions are done. Latest RTP is done. Even this case law is done. I told you how to read. Now we are coming to the last 5 attempts and last 5 RTPs. Important questions. Are you following, guys? Now, in this session, we may not have time to do all the 60, but I'm going to share the answer with you. Whatever we already did, we will run through them. What is pending, we will do it. Are you able to follow, guys? All of you with me? So, 58. For those who are watching recording, please read and go through the key because we already did this in the class. 58 done, guys. I'm coming from reverse. Because 1 to 25, we covered many questions. Next, 57. Read the question, try to give the answer. Everybody, yeah. This exam question, guys, November 22. December 22 basically. That time was, now you're reading in December. Last time it was exam was in November, December, whatever, that attendance base. Answer, guys. What happened? Y is 21 years, lost some mental balance after death of parents. So he was left with his grandmother aged 85, incapable of walking and dependent on him. M is the neighbor, out of pity started supplying food and necessities to both of them. Mr. Y and grandson used to live in the house built by his parents. M also provided some financial assistance for emergency treatment. Can M recover the money? Which concept? Quasi contract first. Necessities supplied to a person incapable of entering into a contract. Then if you supply necessities, you can recover from the personal property. What is the personal property here? You can recover up to. Beyond that, what you can do? Nothing can be done. Yeah, you can sue. Sorry. You can sue the property. Whether M will succeed in recovering the money? Yes. If the personal property is the house, that also can be sued. What is the maximum amount that can be recovered from M? Have they given the value of the house? Whose house it is? Built by parents. So we don't know whose property it is. It should be in the name of Y. Okay. Will the provision above apply to a medical emergency given to grandmother? Yes. It's for necessity supplied to the person or his dependent. Let's check the answer. This question number This will be the key I'll be sharing in the group right after our class. So you can go through. Online students, check the description of the video. I have two versions. One is detailed answers. One is one-line answers. Which one you want? Fine. I'll try to send both. Detailed I'll send. First case. Claim for necessities supplied. If person is incapable, you can claim from the property of such incapable person. Maximum here is how much? 4 lakhs, and rest from the house of the. Look at the assumption. Assumption is that Y has inherited the property. Same thing what Harish said. What about the property? It has inherited. Are you able to follow, guys? Last one, necessities include emergency treatment, and hence he has to support, he has to pay for this. Are you following, guys? Clear? Easy, guys. This is a past exam question. This is the first question we are seeing today. What we saw is RTP and own questions. This came, you are writing December 23. This came last year, basically 1 year back. How many marks? 6 marks. How many of you got the answer before we discussed? Put it in the pocket, write 6 there. Next, this also is exam question. I told you, examiner loves this question, LLP. What he asked, the LLP is a type of partnership in which liability is fixed to the amount of the investor. Then LLP, private public company, is a tightly held business and incorporates the qualities of both partnership and LLP. He wants you to explain true or false. Yes, look how he explained that. That's question number. Differentiation between LLP and company. It's there in the book, guys. Difference between LLP and partnership. I gave you mnemonic, small ABCD. That is for LLP and. This is LLP and. Be happy. This came in exam. So what will come? What is left to come? LLP and partnership. Small. Whatever that mnemonic we discussed in our class. Are you able to follow, guys? Clear? Limited liability company. Company. Okay. Following, guys. Then next. Are you all following, guys? LLP is partnership. LLC is company. But we don't use the word LLC because key had it. I copy pasted. That's it. Next. November 22. One more question. 4-mark question, guys. Did we do this? No, then quickly read. Now these are exam questions. I am not going to read. You are going to read. I'll give you a few 1 minute max per question. Try to figure out the answer. Push yourself, guys. Last 30 minutes, push yourself. Recording can pause, but you guys can't do it. So push yourself and then you can go home. Anybody answer? What concept? What is happening here? Follow. R is a manufacturer of toys, approached MNO Private Limited for supply of raw materials worth lakh and 50. So R went and asked the toy company, MNO. Okay. R was offered a credit period of 1 month. We told R to pay after 1 month. R went to the company prior to the due date and met C, an employee at the billing counter, who convinced the former, who convinced the MNO that payment can be made to him as the billing cashier is on leave. R paid the money and was issued a sealed receipt by C after the lapse of due date, R received a recovery notice from company for payment of. So R went and made the payment, but later company is saying you didn't pay. I paid to some wrong person. Okay. R informed the company that he has already paid the above amount. Being an outsider, he has genuine reasons to trust C, who claimed to be employee and had issued him a receipt. The company filed a suit against R for non-payment of dues. Discuss the fate of the suit and liability of R towards the company. What concept, guys? Doctrine of indoor management. How many of you got that? No one. Doctrine of indoor management. Look at the answer, we'll see in detail. Which question is that? 50? 55 of. Doctrine of indoor management. Now, follow, guys. As a third party, or I should be aware of what is happening inside the company. But what is happening inside, I can't exactly go and check if the seal is correct. So doctrine of indoor management protects the third party against the company. So first case, R is not liable to pay 1,50,000 to MNO as he had genuine reasons to trust C, who issued a seal. We are discussing concept of indoor management. Outsiders are not deemed to have notice of the internal affairs of the company. They are entitled to assume that the acts of the directors and other officers of the company are validly if they are within the scope of their authority and if it's within the articles. Second exception, what if no receipt is issued? We have that in the question. Did I not read it? Okay. Would your answer be different if a receipt under company seal was not issued? If your receipt is not issued, then your suspicion of transaction, you have to check that. You didn't check after suspicion. So suspicion of irregularities exception, in this case you become liable. How can you take a receipt without seal? You should have suspicion of transaction. Are you guys following, guys? How many marks is this? 4 marks. Now in the main exam, follow, guys. There will be in every subject, especially law accounts, because we're writing theory papers, out of 100 marks, when you do maths and economics MCQ, will you know answers for all the 100? Honestly, will anyone know answers for all the 100 in maths and economics? No. You might know 70, 80 or 90, correct? That means when 10, 15 marks, you will not know or it will be challenging for you, correct? So similarly in accounts and law also, out of 100 marks, approximately 10 marks in each paper. You may not know. If you know for all 100, good. But 10 marks, it will be yes or no. You may not know. And that is normal and accept that. Don't get stressed in the exam. Sir, 10 marks, I didn't know what to do. That's it, gone. Hello, you focus on the 90 marks that you know and write that well. This principle is applying only if you don't know like 10 or 15 marks. Sir, 100 marks, sir. Only 40 marks I know. 60 marks I don't know. Okay, I'll see you in June. Okay. But mostly there will be 10 to 20 marks which you will not know. Sometimes when I read also, I won't know the answer. So that kind of challenging questions will be there. Don't get thrown away or lose your confidence because of those 1-2 questions. Are you following, guys? Whole paper will not be like that unless it's maths. Are you following, guys? Okay. Now come back. We are done with 55. 54 did we do? We did in our class in previous days. That's why we did slowly few questions. Recording students, read the question. Ruby stone only is that blue diamond which we finished. You read, answer will be given for recording students. 53 did we do? No. Read 53, guys. I think we did this now. We just now did as part of RTP. This CA, right of transferee interest. We did it. This was part of your December 23 RTP plus May 22. Are you following, guys? Next. Again, May 22. This also we did, guys. We started today with this question. This also is what? December 23 RTP. First is putting in exam, then asking in RTP. Should be opposite. Okay. We remember this, guys. We did this. We started the class with that. Next. December 21 exam question. We have gone back one more year. Go through. Come on, guys. Only 20 minutes more. 5 to 10 questions we can do. Put the best efforts. Come on. Which concept, guys? Sale by description, but it's meeting the purpose for which it is purchased. 51. Let's go check the answer. Sale by description, implied condition. There are two answers for 51, guys. Question is small, but answer they are given two answers. One answer says you can reject the goods because it doesn't meet with the description. Other answer says, so what? It still meets the purpose, commercially fit, so you can use that. Are you able to follow, guys? So suggested answer itself gives us two alternate answers. 51, condition as to quality or fitness. Alternate answers, look at this. The condition as to reasonable fitness relied on all of this, therefore is fit for the purpose for which it was ordered. It means implied condition on part of the seller is fulfilled. See, you did all these three things, so it is fulfilled. Cannot reject the timber. Alternatively, sale by description, you can reject the goods. Are you following, guys? But reason should be correct. If you are rejecting na implied condition as to sale by description, if you are accepting or if you have to accept quality or fitness. Are you following, guys? Are you able to connect? Which one to write? Don't write both. Any one, both are correct. Both you will get full marks. Suggested answer itself uses the word alternatively. Are you able to follow, guys? Sale of goods act, deliverable state. No, this is not deliverable state. No, it's not meeting description. More of quality point than deliverable state. Okay. Sometimes it will work. See, I might have asked for a podium for the house studio, which is this height. He would have given extra 2 centimeters. Still, I can use. In Uber, when you book cab, it says cab is coming in 5 minutes. He came in 7 minutes. Are you going to sue him? Panla, but panviya. You can't sue, but will you sue? You have the right. That's why you have the right to reject and sue. But you can also accept. Are you following, guys? Clear? This also I think we discussed, guys. What is a partnership? What is not a partnership? Quickly, guys. From reverse. X and Y bought a commodity and to sell the commodity. The intention of sharing profits equally. Partnership. Yes. Previous question. Next. Co-owners, renter. No. Some individuals form an association. This also no. We read this. Two co-owners agree to conduct business in common for profit. Yes. This also. Basically exam question. This is RTP question. December 21 and now RTP. A and B jointly own a car. They use personally on Sundays and holidays and let it on hire on taxi other days and equally divide the earnings. Is this partnership? This is new. A and B jointly own a car which they use personally on Sundays and holidays and let it on hire and divide the profits. Is this partnership, guys? Yes or no? Check the answer. 50 up. Yes. Now, personal issue should not be used if their partners don't agree for it. Here partnership are agreeing for it. So we can use for personal use. Is there a second answer? Okay. Alternatively, car is used personally only on Sundays and holidays. Most part of the day, the taxi main purpose of the owner is for letting purpose. Agreement for dividing profits. Second, not a partnership because sharing of profits of gross returns from property, it would not, they are treating it as joint owners. So they are giving both the answers but justification. Why they are giving both the answers? Because the question is not fully clear with its facts. Are you following, guys? This answer is both answers, not I am giving it. ICA suggested answers. Are you following, guys? Clear? Fine. Next question. July 21. Now we have moved to July 21 attempt. Okay. Is this done, guys? Basmati rice. This came when, guys? Now. December 23. RTP. I think this time ICA did not make new questions. They just used the old questions and collated and gave you the RTP. Are you following, guys? Again, July 21. Go through. Mr. M is one of the four partners. He owes a sum of 6 crores to his friend is dead. He is unable to pay on due time. So he wants to sell his share in the firm to Mr. Z for settling his amount. In light of the provisions, discuss. Can you transfer your interest to somebody else? Yes, right of transferring interest. Can you transfer by way of sale? Right of transferring interest, guys. That section 29 we saw in RTP. You can transfer the share, but you can't become partner. Only get the share of profits. What would be the right of transferee? Z. In case M wants to retire from the firm after 6 months, he can join as partner only if the other partners give the consent. Otherwise, what will be his right? Right to recover profits only. Correct? We saw similar question in RTP also. Question 48. Same concept. Where is that? Yeah, 29. Transfer of interest. I told you that time market as important, guys. Came in the past, can come again. Here, yes, he can transfer by way of sale, but he has right only to receive the assets and the share of profits. But he will be entitled to join only if the other partners give the consent. Are you able to follow, guys? That's the answer. See if there's any other point. Yeah, receive from the firm's asset. Yes, because if you get share of profit, share of property. Your right is share of profits and share of property. But you can't interfere with the management and profits of the firm. Section number 29, we are seeing it twice today. Came in past exam and RTP. Yes, from the firm's assets. That's his share. No, but it's not a partner's personal liability. It's your share in that business. I'm withdrawing money. It's like withdrawing money from my business for which I have the right. You're withdrawing money from the business. That's your business. I can withdraw. Following. Go through section 29, important, July 21 exam and in our December 23 RTP. Now again, past exam question I have stopped, guys. I have stopped over here. That means we have seen all the questions from July 21 till the latest exam. Now these are not all questions. What are these? Whichever I felt as difficult. Rest of the questions you can teach me. It's like that. Okay. If you want, we will see one or two questions like that for your satisfaction. We'll go till 1:30, guys. Another 15 minutes. How many hours we can do? And then we'll stop. Now, RTP, June 23. One before RTP, guys. This we saw, guys. We saw this, no? Hello? Same question where we saw December 23. I told this same ICA decided to copy from previous things and put into December 23 RTP. This came from June 23. Are you following, guys? Don't ask me why they did that. Last attempt. We will take previous summary and give it to you. That means what is the message they are telling you for December 23? Your exam also, we don't have time to frame new questions. Past exam question we will summarize and give it to you for December 23. We will do new question for next attempt. Following, guys, it's just a guess, guys. You learn. Yeah, similar to this only. Past exam questions. Next. Go through, guys. Articles of express provides that board can take up the loan up to 5 lakhs. Company on passing the board resolution, in that case loan amount in excess of the limit, a special resolution is required. Now, due to urgent needs, board applied for loan in reputed bank 10 lakhs without passing the resolution in the general meeting. Board gave an undertaking to the bank that SR has been passed for that. They lied. They lied to the bank saying SR has been passed. The bank, on believing such undertaking, lent the money. On demanding the repayment, company denied the payment ultravised the company. Is it valid, guys? Which concept again? This time you got it. Doctrine of indoor management, defense for the third party. But what if company did not mention this? Board gave an undertaking to the bank. This was not there. Then what comes? Doctrine of constructive notice. If company gives a loan, if bank gives, to summarize, see, bank gave loan of 10 lakhs because board of directors told they have the power to take loan of. So I believe them and gave. So doctrine of indoor. But if the bank gives loan of 10 lakhs without checking if they have the power, and the company does not have the power up to 10 lakhs, they have only for 5 lakhs, then it becomes doctrine of constructive notice. Are you following, guys? Clear? Next, RTP June 23, go through, guys. Shyam, Mohan and Keshav were partners in some company. They mutually decided that Shyam will take responsibility to sell the goods. Mohan will do the purchase of the goods for the firm, and Keshav will look after only the accounts and banking department. No one will interfere in others' department. Once when Shyam and Keshav went out of town, Mohan got the information that the price of the goods is going down. Sharply due to some government policy, they will result in heavy loss if the goods are not sold immediately. He tried to contact Shyam, who has authority to sell the goods. When Mohan couldn't contact Shyam, he sold all the goods at heavy loss. Sorry, he sold the goods to save the firm from heavy loss. Can he do that, guys? Because now he doesn't have the authority. He doesn't have the express authority, but he still sold it. Is the sale valid? Reason: emergency case. Sale is valid. Are you following, guys? Next again. Go through, guys. RTP June 23. Previous RTP is always important. He will not ask in December 23 RTP. He likes the previous RTPs. Examiner is like that. Okay. Mr. Ram, Rahim and are working in some school as teachers. They're very good friends. They jointly purchased the flat which was given on rent to John. It was decided between landlords and tenants that the rent would be 10,000 per month inclusive of EB bill. It means EB bill will be paid by the landlords. Landlords by mistake did not pay the electricity bill for the month of March. Due to this, EB department cut the connection. John has to pay the EB bill and some penalty. John claimed 3,000 from Ram, but Ram replied that he is liable only for 1,500. John said that Ram and Rahim are partners, therefore he can claim the full amount from any of the partners. Explain the provisions under Indian partnership. Is Ram liable to pay full amount? Two concept. Payment made by interested persons is Indian Contract Act. Payment made by interested person. But here they are asking as per Indian Partnership Act. So you can't write that. Are you following, guys? Here, partnership, should they, one partner is saying he will pay only 1,500. He is asking him to ask the other partner for the full amount of 1,500. Is he right, guys? No. Partner's liability is joint and several. Both the partners are joint and several. Now, basically what happens is, Ram can pay whole amount to John, but he can recover from the other partner how much, guys? 1,500. Let's cross check the answer once. Question number. So now what happens is this a, okay, hence there is no, okay, they are saying there is no partnership. Got it. So let's check the answer again, guys. Follow. For partnership, there has to be an agreement to carry on some business, share profits, one of them acting for all. We missed that point. This is not even a partnership. So because it's not partnership, you can't claim the money. See, the answer I told you is basic if this is a partnership. So if it is a partnership, you can claim the full amount of 3,000 from the party and they will share. But since it is not a partnership, it is only a co-ownership, you can claim only 1,500 from John and the other 1,500 from Ram and the other 1,500 from Rahim. Are you following, guys? Clear? Next. Fine. Sale of Goods Act. Ayushman is the owner of a residential property. He appoints Ravi, a mercantile agent, that Ravi will not sell the house at a price less than 5 crores. He sold the house for 4 crores. Who buys in good faith? Now what Ravi did, after selling for, who's the agent? Ravi also misappropriated the money from Mudit. So Ayushman appointed Ravi, who sold it to Mudit. What Ravi did, he was supposed to sell for, he sold for and took the money and ran. Now Ayushman is filing a case against Mudit to recover the money. Can he do that? No. Because Mudit purchased in good faith. So what should Ayushman do? Search for Ravi. Sorry? Sale of Goods Act, residential property, immovable property. Let's see if they give the same answer. You are right. 43, that should be the answer. But they are discussing concept of mercantile agent. Somewhere they should give. You are right, guys. Immovable property, but they are proceeding with the concepts like this. So in exam, if it comes, what you will do is write the answer, but additionally give a note. Sale of goods is not applicable for immovable property. Following, guys. Okay. No, no, that is clearly not partnership. They are discussing only concept of joint ownership over there. Able to follow? You understood the answer, guys? Sale by mercantile agent, sale by non-owner. Now, go through this one. We'll just do last one or two questions. Okay, go through this. I just want you to see, and these questions are difficult. Again, I'm telling you. Is this done, guys? Test the question. If it's done, yeah, window question. Two alternate answers. It's done. Go and go through this. RTP June 23 is a good RTP. Lot of difficult questions. That's why I put everything into this. Go through this. Answer, guys. What's the answer? What is happening? There is a rice sale. Before Avyak picks the goods from warehouse, the whole wheat in the warehouses. So goods are destroyed not because of the fault of seller or buyer. So contract becomes void. Are you following, guys? Section 7-8. We saw theory in the RTP. Now we are seeing it fully here. Yes. Next one. Okay, let's do 39 and 40. Try to do both, guys. We'll discuss both quickly. One second, I didn't read the whole question. Bhaskar says the wheat in his warehouse in the custody of Kishore. Warehouse keeper Kishore confirmed that Avyat can take delivery of the goods from him until he is holding the wheat on Avyak's behalf. Before Avyak picks up, correct, you're right, guys. It talks about what, guys? Constructive delivery. Check the answer. Constructive delivery 41. Three types of deliveries: actual, constructive, and symbolic. When delivery is affected without any change in custody or actual position, it is called constructive delivery. Now, yeah. So on the basis of above provision, it's clear that the position of goods have been transferred by constructive delivery. Hence, Avyak is not right. He cannot claim the price back. You are right. I didn't read that whole question. Sorry, guys. Yeah. Now do the last two questions quickly. Yes. Both is fine. So this 39 we didn't do exactly. Not the same question. 40 we did what, guys? Mukund wants to sell his car, appoints Parth as minor. Parth, that car should not be sold at a price less than 2 lakhs. Parth sold it for 1 lakh 50. Even if the agent is minor, can Mukund recover from Parth, guys? No. Agent can be a minor, but you cannot recover from the minor. Can Mukund recover from Naman? No. Mercantile agent. In this case, can you tell me which gets adjusted first? There are three dues: 12,120, 5650 and 9680 in May 21. When I pay this 9680 will get adjusted with, because amount here it's implied communication. When I pay 9680, it's adjusted with, then 15,000. Order of time, first 12,000, 120, then balances 5650. Are you following, guys? Which one? First one, Now we're in 2022. But order of time it says whether time barred or not. Correct? No, see, when the question is silent, see this you understood 9680. But when it's 15,000, when it goes in order of time, when both parties are silent, we adjust in the first loan. No, what is the provision saying in order of time? You can adjust with a time barred loan, yes or no? In exception, yeah, exception is what? Time barred debt is the exception. Now, time barred debt is 3 years default, but time barred debt provision of 3 years changes state by state. So, question should mention its time barred. Let's see what assumption they have taken. 13. Generally, it's 3 years. Yes. Is it given as time barred? I don't think it would have been given. Kuduthirukano? Now follow first one. 9680 will be appropriate against, because it was due in 2021. Check of 15,000 can be appropriate against even though it is time barred. That's what we discussed. So if you remember seeing this, in order of time, if you look at the wordings in the book, time barred debt is for other things, but order of time, whether it is time barred or not, if you look at the wordings in the book, it comes in performance of a contract. Whether it is time barred or not is the wordings. Appropriation of payments, if you see, where neither party makes an appropriation, payments shall be discharged in order of depths of time, whether they are time barred or not. That's what we discussed. We took this long back. I remember it's whether time barred or not. The exception is only for the other one. Look at this. Disputed debt and time barred, but here whether it is so this is one, whether they are time barred or not. Are you able to follow, guys? Previous point, if you see where the debtor has omitted to intimate no circumstances to approve, creditor may apply its discretion to any debt actually due and payable to from debtor, whether it is recovery or not, and not barred by limitation. So creditor is applying means he can't apply to time barred debt. So if you see, that's what we discussed. Creditor means he can't adjust with time barred debt, but if it's order of time, it will adjust with the time barred debt. Are you following, guys? Logic is, if creditor has the option, he will of course go with time barred debt. But order of time, law doesn't know that, so we go with the first one. Are you following, guys? I remember teaching the same thing. I'm 100% sure. Teaching the same thing. Long back, we did discuss. Same notes are given. 100% I gave the same thing. Follow, guys. Good, we solved the question. Clear, guys? Okay. We will do the last one question and wind up. Yes, same provision. Otherwise, default is 3 years. So mark this also important. Can you see RTP June 23? All are good questions. Okay, we did all the big questions in that. RTP June 23 is over. Now, what I will do, presentation you guys already know. Just clarifying one point for presentation. 4 ways: facts, provision, analysis and conclusion. Provision, analysis and conclusion. You can write in both, guys. If you feel facts is a lot, you're taking away time, don't write the facts, write provision, analysis, conclusion. Analysis should be in detail. Like I said, facts ka how many marks? So don't write 4-5 lines, 2 lines if you can write, otherwise you can skip and write, the rest will repeat. Are you following guys? You know how to write? Now just for your confidence, to show you exam questions are easy, go to past exam questions, previous year question papers. We are just going to do one question or few questions. Which attempt do you want to choose, guys? Which one? Latest exam, it will not come in exam. June 20th, I'll still open it. Anything else? December 21. Okay. Look at the exam paper, guys. How easy it comes. Partners have jointly promised to pay 6 lakhs. One became insolvent. How much will others pay? What is this? Joint and several liability. Joint promise are able to follow. Next, look at these questions. See if you are able to understand this. This is past exam question. Quickly go through. Are you following, guys? Clear? Easy questions. Come down. Look at this. This is what we just now saw in exam. So it came. Look at other questions. Look at the direct questions. What do you mean by capital? What are the classification of capital in company law? Equity capital, preference share capital. That's it. Then what do you mean by quasi contract? What are the salient features? 5 marks. Sharing profits is not conclusive with the creation of partnership. True test of partnership. Are you following, guys? Take June 23. I'm just showing you randomly 2-3 questions. Whether it's associate company or not an associate company. Next. Now, bilateral mistake, that point. Stranger to a contract cannot file a suit in breach of contract. Comment and explain the exceptions. Privity of contract. Liabilities of LLP and partners in case of fraud in LLP. 5 marks question, guys. Liability becomes unlimited. This is June 23, latest for your satisfaction. Explain about registration process of partnership firm. They tested for 6 marks. We saw the detailed process. Then M, the employer, introduced his employee to sell B to one of his room and market value to secure promotion. Later on, B changed his mind and decided to sue A. Examine validity as per provisions. Mr. B, A, the employer induced his employee B to sell his one room flat room at less than market price to secure promotion in the firm. What is this? Undue influence. 2 marks. Are you following, guys? So can you see the difference? Case law questions, and again you get direct questions. Explain concept of lifting of corporate veil, differentiate void and voidable contract. What are the rights of partners in respect to conduct of business? We saw those 3 points: right to participate in business, right to take decisions, all of that. Then what is small company, guys? 3 marks. Latest exam they ask small company. This time they will ask small LLP. Are you following, guys? Clear? Hello? So now what I want you guys to do is, we solve these questions. Are you getting good confidence in law? So the remaining questions over here, you will anyway be having the answers for all of this. Do the answers, go through at your end. Now that once you finish studying, you have to practice these questions, go through, and in the ICA website, can you see from May 2018, there are question papers till June 23. These are past exam questions. It is available with answers. There is a part called suggested answers, foundation, law, till, okay, they gave it till December 21, but you know there are so many apps where you can easily find that suggested answer question with answer, guys. So you have to download all these PDFs, and at your end from the May 18 till June 23, get it downloaded. Like how we practiced today in 2 hours, We did at least 50 questions, 50 to 60 questions. So you have to sit one day, do all these questions, then nobody can stop you from scoring full marks with answers. You don't have to write. Read the question. Hey, I know the answer. Go read the answer. Then you're tuning your mind into the box of how ICA will ask. If you are not going to do this, then suddenly you will go practice an exam. Are you following, guys? It's like how a cricketer practices and nets to go for the main match. You have to do this. It's like reading like newspaper. Following, guys. That's it. We are done with our law classes. Thank you, guys. All the best for the exam. Perfect.